If you are joining or if you have a colleague who is interested in this area that has not yet joined, please tell them that we are live and we'll be starting in exactly 2 minutes from now. So let's get sharing this with our colleagues so that they can be able to join this session. I'm excited with our panel this afternoon. We have a panel that is diverse with wide knowledge on this subject matter, and so we'll be learning quite a lot from them. So let's get sharing the link. Let's get encouraging our members. You tell a friend that we are on this afternoon, and we'll be back in a minute to officially start the session. Thank you. All right, it is 3 minutes past the hour of 2. And ladies and gentlemen, speaking to you live from the East Africa Law Society House is Gabriel Achai. We are honored to host you this afternoon for this very important discussion on data protection and privacy. And today we want to examine the intersection between technology, privacy, and gender. And this afternoon, we are very profoundly honored to have the privilege of having our one and only chairperson of the Women Lawyers Committee, Miss Angela Munga Mwadumbo, to moderate this session. But for those who do not know Angela is a lady of many talents. Not only is she the chairperson of the ELS Women Lawyers Committee, but she's also a chartered she's a member of the Chartered Institute of Arbitrators and has vast experience in alternative dispute resolution, primarily in commercial litigation, arbitration, banking, finance, defamation, judicial review, employment law, and professional negligence. She is a member of the Law Society of Kenya's Advocates Benevolent Association and FIDA, the Federation of Women Lawyers. She's quite passionate in gender and women issues. That is why she dedicates her time and leadership to the Women Lawyers Committee. Chairperson, you are welcome to take on the session now and introduce your panel. Thank you.
Thank you very much, Gabriel. Good afternoon, everyone. It is my distinct pleasure to welcome you to this webinar. Karibuni sana, bienvenue tout le monde. As Gabriel has said, my name is Angela Munga Mwadumbo. I am the chairperson of the East African Women Lawyers Committee. And as the committee, we have the distinct pleasure to offer you this webinar. But before we get into the substantive webinar, let us have some few housekeeping rules. The webinar today is structured as a panel discussion whereby our panelists will give a presentation Then after all the panelists have given their presentations, we shall have a plenary session. So members, if you have any questions, any burning questions, you can type them on the Q&A section. However, we want to have a very interactive session. The chat section is active, it is live, so you can post your observations, your reactions, and your comments on the topic as we go along on the chat section. You can even greet each other. You can greet us on the chat section. You know, as the East African community, we are all neighbors, so we might as well take this opportunity to network on the chat section. Now, I know the poster that went out had 4 panelists, but let me convey the sincere apologies for one of the panelists, that is Ms. Teresia Munywoki. Unfortunately, she is indisposed and she will not be able to join us for the session today. However, we have 3 other very eminent panelists who are experts in their particular fields. So we shall, the topic will be done justice. So what is our topic for today? You may be wondering whether there is an intersection between gender and data protection and privacy. So wonder no more. That will be answered today, as our topic is data protection and privacy. That is, we shall examine the intersection of technology, privacy, and gender. We all know that we are in the information age, and information is the next best-selling currency after the dollar. And nowadays, information transfer is very easy. Exchange and transfer of information is done at the touch of a button. This data may be private or public. It may be shared by the individuals themselves or by third parties. So what does this, what effect does this wanton sharing of data or privacy, does it have, especially on women? Of course, we know at the back of our minds, we have the argument of the digital gender divide. So with that background, it is imperative for us to analyze, and critically so, the issue of data privacy and protection through a gendered lens. To help us do that, we have the distinct honor of having a panel made up of industry experts who are ready to break down this topic for our better understanding. So we have with us Mr. Cephas Okoth, who is a data protection consultant and a privacy technology advisor. We also have Ms. Edith Michael Mtwewe, who is a senior consultant on technology at Victoria Attorneys. And we have Ms. Rose Mosero, who is the Deputy Data Commissioner. So to kick us off in this topic, we have Mr. Cephas Okoth, who will take us through the interplay of technology and data. So Mr. Cephas Okoth, just a minute, I pull up his bio, is a data protection consultant and a privacy advisor at Privacy Innovation Lab. He has 7 years of work in cybersecurity across security assurance, GRC, and business development. Currently, Mr. Cephas works across operational and technical privacy, from privacy reviews and assessments, implementation and tooling, technical privacy, and more. He bears various credentials, and since he's a data protection and privacy technology advisor, all of his credentials are in acronyms. So because we are in the data age, we should be able to either know or find out what these acronyms mean. So his credentials are in GRC, cloud and security, including OneTrust, GDPR, AWS, CSA, SOC 2, GRC, and others. I assure you, I was not reciting the alphabet in a disorganized manner. Those are actual credentials for Mr. Cephas. So, Mr. Okoth, take it away.
Yeah, thanks, Angela. Thanks for the intro. I'm not so much a fond of those, of course, because of the four-letter credentials. Yeah, thanks for the intro. Can you hear me clearly, Angela?
Yes, we can hear you and we can see you.
Okay, super. All right. It is my duty today to talk about privacy and technology and the interplay of the two, of course, within the context of the obstacles, the opportunities, and some of the some of the issues across both that can all of us can sort of take back and implement, in our own environments. So I suppose by the nature of the organization that a lot of us here would be legal professionals. That's correct, Angela. But even so, we could still be practicing in matters technology, matters emerging tech, and anything around legal tech or tech legal. Jumping straight to it. Yeah, so technology and privacy. Technology in itself is something that has been with us for too long. Yeah? And technology, of course, you can look at it from many different angles, and sort of categorize them across many different domains. Okay, even some of the more mechanical sectors or mechanical domains would still be considered technology domains. But I suppose for the context of this conversation, you're talking about digital technology, right? Across the spectrum of it. So the context of my discussion today would be digital technology specifically, but then considering data protection and privacy, and how even as technology is there, you could still argue that privacy is older than technology, or privacy or technology came after privacy, and things like that. If you go to the more philosophical or fundamental conversation of the two, but keenly, how do these two interplay? And there's a lot to talk about in terms of the convergence of the two. But I've chosen some specific issues that I feel personally, and also what I've seen in practice would be more relevant for both that, privacy legal or privacy technology professional, going forward. So let's talk about how technology, digital technology in this case, applies to data protection and privacy. And I've highlighted just two key areas that I believe are very common. They're very important to note, especially for those who are doing privacy practice, and more leaned on the implementation and technical aspects. You'd want to consider first privacy technology, and that again could mean different things based on who you're asking. Is it technology for privacy or privacy for technology? But that notwithstanding, I really want to emphasize on the aspect of using technology to manage privacy, both in terms of the compliance, and then both in terms of the technical implementation of some of the requirements for privacy. So first thing you'd want to consider is privacy management, right? And this is very straightforward in the sense that, yes, we have privacy privacy and the laws and the regulations and legislation that we all need to abide with, and we have obligations under them. But then as you're building internally within an organization, companies or businesses, compliance, building compliance to these laws and regulations. How do you manage that, right? Typically, there's level 1, level 2, and even level 3, if you can say. So level 1 is where you normally talk about the simple technology, brick and mortar, almost method of managing your privacy compliance. And here you'd want to consider the simple tools like documents, e-document tools, Excel tools, spreadsheets, and all of that, digital forms and all of that. So those can help you implement your privacy compliance. Even getting to a point where you can integrate and interconnect all of them, and maybe put in some robotic automation, stuff like that. But that is sort of the base in terms of how you can manage your privacy compliance. And then there's a level 2 where you can now consider more proper digitized workflows, proper digitized tools that are more robust and are more integrated for use in terms of your privacy management. And here, of course, I'll give a simple example like OneTrust, which is a very common name in the space. It gives you those digital tools that are sort of built out to be interoperable and really gel well and give you more or less like a robust, holistic suite of applications to use. Again, that digitization is key. I think it's important to appreciate the importance of that digitization within the entire context of digital transformation that we all have going on, in our different spaces. And then, of course, there's the next level where you can now talk about automation, not just robotic automation, but AI sort of automations, and next level automations that you can sort of build into the level 2 digital privacy management. And you have a more new school and forward-looking systems for privacy management. But again, the reason I'm impressing upon you this breakdown is just to understand that, hey, we need technology in some shape or form to help us manage our compliance work, and that gives us more efficiency. It's even disruptive, if you can put it that way, because it then helps you to potentially do things faster, cheaper, more easier, and more efficient, and the output is far much better than if you'd have done it a more traditional way, right? The other side of the privacy management coin is your now standard privacy operations, typical stuff that you do, privacy compliance work, the assessments, DPIAs, PIAs, DAs, inventorying, data mapping, and all sort of management in breach, and the other components of compliance framework. Again, the purpose of level 2 and level 3 that I've just explained will then be able to capture these frameworks within these particular digital management tools and give you a more vast way, more efficient way to be able to drive those privacy operation work. But speaking of privacy operation, is yes, the typical assessment, implementation, and kind of work, but a big part as well leans on the more technical aspect of it, where we talk about the TOMs, very common 3-letter word, technical organizational measures, right? Organization you can equate organization to operation, so it can be pretty straightforward. But when it comes to the technical, where you now have to consider the technological application of different measures and controls that you can specify as part of your privacy operations. you then need to dive into more or less of the hard tech. You can consider something that is in most of our laws, privacy by design. Privacy by design, much of it is really about implementing actual technical solutions in applications and systems, in products and all of that. And I've sort of captured a few things to consider when talking about technical. And I'll start with this thing we call PETs. At a high level, PETs, which is privacy enhancing technologies, and then we also have privacy preserving technologies or computations, if you can call them. At a high level, these are just suites of technologies or different sets of technologies that help you to hardcore implement privacy enhancing or privacy preserving, computations within systems. And of course, generally they're different because they're different technologies. All of them come with different applications, different capabilities, different strengths, and all of that. But the goal there is that you are using technology in the backend, using technology in the backend, potentially at the data and the code level, to be able to put in those privacy controls, privacy measures within what the designs that you're creating. So maybe just an appreciation of the scope of PETs. Firstly, you could consider some of the more common popular technologies like anonymization and pseudonymization, right? Those who are in privacy must have interacted with this and even recommended this to clients and all that. So those are two popular ways to sort of enhance privacy. Of course, there are other ways, like data masking, things like now some of the more privacy preserving aspects of the same, different techniques to doing it, all of this. So, from simple encryptions, to more hardcore, computations like differential privacies and all that. But just to appreciate at a high level, something that all of us interact with is access controls. So at that point where you need to gain access to a particular service, and of course you need to provide credentials and all of that, there could be privacy techniques that could be applied that could help you, that would help in verification, authentication, without having to have a negative impact or any harm to you as an individual using the data that you provide. So you could consider things like zero knowledge proofs, things like using data attributes, or what you can call metadata of data, to be able to verify, authenticate you at the point of access without having to either expose or deal with the personal data or credentials provided for access. We all communicate using all sorts of digital channels. Of course, I've mentioned encryption. Encryption is a very common in social secure messaging channels that all of us use. WhatsApp, it pops up every other time. So end-to-end encryption really is a way to preserve privacy, or at least the contents of communication, the contents of any personal data within that communication, by ensuring that only the source and the destination are able to decrypt or able to use a key to be able to access that secure communication. Again, that's a very common application of what you can call privacy enhancing technology. And of course, there are many others. We didn't want to dive much into it, but the idea is some of these common security-oriented, which are now being applied to privacy, can be considered as ways in which we can enhance and preserve privacy in some shape or form, including, of course, we as the data subjects, or you are data subjects for your clients and all that, they are able to have the ability to control the privacy of their data. And again, starting with the encryption, you as a client can choose based on the service you're using, you can choose whether to have encryption or not. As simple as all the laptops that you're using, whether it's Mac or Windows, you have encryption options there for your storage, for your certain files and all of that. Again, those are user level, application level opportunities for all of us to be able to turn on that privacy enhancing feature that is provided. And then, of course, within our own products and systems, we can include some of the more fundamental by design, by default features. It could be an icon here. It could be a certain control center somewhere where someone can change their preferences, get their privacy settings and all of that stuff. So again, all of these things can also come within the context of our own application of these systems, and also the culture. And because you're talking about gender, I think there are certain opportunities, some services and products that have some of these features more generally, but also based on the context they can provide more special interest, special groups features. Give me a minute. Okay, great. So another thing is, as I mentioned, privacy by design, which is a very common requirement of legislations, but essentially to break it down in a high level, so we don't get too technical. Basically, PBD, as we call it, is just about shifting every consideration of privacy very, very, to the left, where it comes very, very early on in terms of when you're designing or architecting systems or applications and all that. And there are key benefits to this, both operational benefits and business benefits. That when you're able to address privacy risks or potential privacy harms by putting in features, putting in settings, redesigning your code, the architecting during the development phase, then you're able to avoid dealing with all of these risks downstream, right? Once you're going to market or in production. So that then helps you address risk early, ensuring that later on down the road, you don't have to bear the cost of patching on, building on, features, because you then need to address risks at that point, right? So makes designing or developing solutions much more faster, because you save time early on, cheaper, because then you don't have all these cases where you have to put out fires and all that. So you reduce that cost of maintenance, but at the same time, even for your users, the fact that you have taken care of some of the salient issues early on, then they can have a better user experience generally, but more specifically, they have that opportunity to insert user control, because this data protection and privacy is hugely about the user, subject, the consumer having control, right? So ensuring that control experience of the user then makes you much more inclined to be used, or inclined in terms of value, giving value to the users. And then, of course, by design normally come by default. So whatever, the more default you go in terms of your privacy features, the better you are. Of course, with the option of giving users the opportunity to opt out or turn off a privacy feature that is turned on by default and things like that. So again, all these are part of user experience, but business-wise and operation-wise, they're important in the mid to long term, right? A key principle you'd want to note about protection by design. So here, when you talk about protection by design, you're talking about technical implementation of privacy solutions within our systems and technology, right? Earlier on, remember, you're talking about data protection technology being used for data protection. Here, we're talking about infusing data protection into technology. And the interplay here is important and is built on principles. For example, like we want to ensure that all our privacy efforts are very proactive, so we don't have to be reactive and put up fires and deal with cases down the road. So be proactive from the get-go. We consider privacy requirements, privacy principles, privacy capabilities in our own technologies. This is something you can advise your clients, to really consider, particularly those who are newly building, those who are sort of doing reviews or sprinting. Clearly, we also want to be able to prevent risks or prevent issues down the road, as I've already mentioned. That helps a lot in providing a better user experience. And this is where I come to centricity. Remember, you're talking about gender as a special interest issue. There are other issues like culture. Our culture here is very different from the culture in Middle East, right? How do you, by design, infuse features or infuse, or do you architecting and designing in a way that speaks to that particular audience, or that cultural context, including religious and other factors, right? Across the spectrum. So if you're able to consider these privacy issues in design, in development, you then will be able to cater for some of these contextual issues like gender, culture, etc., within those designs, so that the output of your work really is speaks to the user, captures the user situation, is more centric to the user, and how it gives that better experience. Totality, of course, there are other principles of doing privacy in design in tech. The out of scope of this session. And then one more thing that is also very common is privacy impact assessments. Typically, privacy impact assessments are considered as risk tools or risk processes, audit processes. Yes, which is true, I believe. But then let's look at these impact assessments within the context of technology life cycles. I intentionally indicated their last step before production, right? The use of a system for production. Yes, we do have privacy by design, where everything is built in or considered at code level, at feature level, and all that. But then before you actually have your technology out here and probably full production use, you then need to do two things. You need to do a risk analysis and an impact analysis, right? So that you consider all the risks, even in production. Because imagine you built a house, right? You go to your environment agency, they give you the permits, they do their environmental impact assessments and all of that, and you're given a permit for construction and you do it. But then even once you construct, there could still be risks pertaining that project. Remember, some risk could be external. There could be impacts once the project is up, right? So it's the same thing. So once the system is in production, you still need to consider the risks and the impact that potentially could come into play, during the production or production phase of the system life cycle. Again, DPI is important, and one of the key consideration in terms of technology is defining controls and measures once you've done the assessment. And much of these measures will actually be technology-based, particularly if you're looking at tech-based solutions or tech-based products. So you'd want to consider technology solutions that can then help mitigate some of the privacy issues. So generally, obstacles, what I consider in this case, the interplay of both. Yes.
First,
time.
Let's hold off on the discussion for obstacles. I'll call you back in a bit to tell us about the obstacles now.
Super.
But
Thanks.
for now, let's hold. I know most of us are on the call. Thank you. Most of us on the call are legal practitioners, and we may have been lost with all the technical jargon, but it was important for us to get the view from those ones who create these systems and from the tech perspective. Now, let me bring us back to an area where, as the legal fraternity, we are more familiar with. And I will call upon our next speaker, who is Ms. Rose Mosero. She will tell us about the regional and international commitments to data protection and privacy and how it provides for women inclusion. So Ms. Mosero is the Deputy Data Commissioner here in Kenya, and she is also an advocate of the High Court of Kenya, and she's also in Australia. She is the Deputy Data Commissioner, Compliance and Registration at the Office of the Data Protection Commissioner. Prior to assuming this role, she worked with the office as a legal policy and regulatory advisor and data protection expert after being seconded from the Ministry of ICT, Innovation and Youth Affairs. At that ministry, she served as a legal policy and regulatory advisor to the Office of the Cabinet Secretary. She has served in various task forces, and she has more than 8 years of legal experience. She is a certified information privacy professional and a certified information privacy manager from the International Association of Privacy Professionals, where she sits on the advisory board. She's also a fellow of information privacy, having been conferred that designation by the International Association of Privacy Professionals in recognition of her expertise in the field of privacy and data protection. So before Ms. Mosero takes it up, remember this session is being streamed live on YouTube. And remember to follow the East African Law Society on all our socials. On X, it is the East African Law Society. On Facebook, it is the East African Law Society. On LinkedIn, it is East African Law Society in brackets official. Now, on the chat section, I want to know whether we had followed Mr. Cephas's presentation. On the chat session, let us know. You can type the meaning of PET, the meaning of PP, and the meaning of DPIA. And that is based on Mr. Cephas's presentation that he has just made. So with that, Ms. Mosero, the floor is yours. Over to you.
Thank you so much, Angela. If you allow me, I won't make a presentation, but I will speak to the topic at hand. So the topic that I will be tackling today is specifically on the regional commitments when it comes to data protection, and specifically as they apply to women inclusion. For many of you who've been following, I guess, the discussions in the EAC, but also on an African level, you'll have seen that there are some instruments that talk to data protection. And obviously with the digitizing of this space, or even just the embracing the digital economy, there has been a need for us to actively look at what we can do to enhance security and privacy, not just for the men, but also just the women at large and the population of youth. Women, unfortunately, in participating online have experienced significant challenges when it comes to privacy and security. One of the things that we've noticed, even as an office, as a regulator, is that when they participate online, there's a lot of risks that attach to not just harassment, but also gender-based violence from participation and their privacy issues. So we have a situation, or we had a situation recently where we had to really look at digital lending practices and how exposure of debt affects women specifically in more rural areas, and what that means for them. So in Kenya, which I'm sure is also the same in a lot of other countries, in the East African region, there was a practice of naming and shaming when it comes to debt collection, and this had actually affected a number of women where they borrowed to start a business, for example, and then their information was leaked or their husbands were contacted, which obviously raises quite significant data protection issues, but also applies itself in a way where we look at, we have to have considerations of what gender-based violence in situations like this would have. Now, obviously, again, as I said, the advancements in technologies come with very significant risks, especially for women and young girls who face very unique security and privacy challenges online. And so even as we continue to enter into the space of data protection, which is relatively new for East African countries, there's a need to strengthen the data protection laws to offer these protections and to actively participate and to enable women to actively participate in the digital economy. When we look at the frameworks regionally, we have as a start the African Union Convention on Cybersecurity and Personal Data Protection, commonly known as the Malabo Convention, which was adopted or drafted in 2014, but only came into force in July of last year. One of the commitments was to ensure that citizens or personal data and privacy of all citizens, specifically when it comes to vulnerable groups, such as women, were protected. However, many of the African member states have not ratified this particular convention, which makes it difficult for them to, for these commitments, I guess, to find their way through to national laws. We also have in the EAC conversation about having a model data protection law that will actually look at a methodology of or framework that will harmonize data protection laws that are already existing, as well as data protection laws that are up and coming. So, for example, we've got, I think Burundi is still drafting their data protection laws. South Sudan, I think, is still drafting their data protection laws. Somalia has its data protection laws in Parliament at the moment, but there needs to be obviously consideration as to what commitments and what frameworks are being put in to actually protect women and vulnerable groups. In Kenya, for example, there is provisions within the Data Protection Act and also the data protection regulations that talk about specific safeguards that need to be put into place when it comes to women. And so not women specifically, when it comes to children and vulnerable groups. This means that, and I'll just go back to what Sifis was stating, there are additional protections that need to be put into place, such as doing a data protection impact assessment when you're dealing with vulnerable groups, such as ensuring there is a mechanism to put in more or to implement privacy enhancing technologies when it comes to processing data specifically relating to vulnerable groups. Issues of actually having consent provisions in place, perhaps for processing information that relates to young people who could also be women. And so these are some of the technical or legal aspects that come to protection of women specifically. One of the initiatives that we've also seen on a regional level, which is very commendable, is with the African Continental Free Trade Agreement. We have a women and youth in trade protocol as part of that, which looks at not only ensuring that there is involvement of women and young people within the African Continental Free Trade Area, but also ensuring that there are some protections that have been incorporated, such as protection from cyber harassment as well, so that they can actively participate in trade across the African region. One of the other things as well when it comes to regional initiatives, Smart Africa Initiative, which is, for those of you who haven't heard of it, which I'm sure most have, it's a framework that looks at African countries. I think at the moment we've got 33 African member states that are in the Smart Africa Initiative. It is a coalition of the willing, so to speak. And they look specifically at ensuring that they've enhanced the digital economy as well as smart and digital initiatives when it comes to really boosting the economy of African member states. One of the things here is there is an ongoing initiative to promote data protection and privacy as a fundamental right, and obviously ensuring that women can participate in the economy without fear of privacy violation and online harassment. One of the things that has come about by the inclusion of, I guess, or the enactment of data protection laws across East African member states is that there is seemingly more empowerment when it comes to women, especially where they have control over their data. Previously, a lot of information about women would be collected, not necessarily with consent having been obtained, and this would then have significant implications. As I've said, there's implications when it comes to gender-based violence, even deaths in some instances. We've even seen in some other instances people who have been, or women who have been shamed from societies that have then led to and unfortunately suicides and the like. And so in this consent provisions, even though it is effectively something that is available to everyone, there's a lot more control when it comes to the data that women have, controlled by women on their personal data, which effectively empowers them to actively participate also digitally, because they then can, whether it's by exercising their rights to access of information, exercising their rights to object to processing of personal data, also just ensuring that they are informed as to why they're giving information. And this has come to be important not only just in the inclusion aspect when it comes to participating online in the digital space, but also in terms of inclusion when it comes to the data that is collected for the purposes of research, for the purposes of policy, and things like this. So people are able to actually give information that is correct, knowing exactly what that information will be used for, as well as appreciating the consequences of not giving the information, but also the consequences of giving that information. And so there is a lot more control that is exercised in that regard. And this obviously has paved the way for ensuring that there is an equal power dynamic as well when it comes to organizations that are collecting information when it relates to women, but also there is it really does affect the imbalances when it comes to I guess coercion to give consent and things like this. There's mechanisms available to women to actually ensure that they can bring to task or bring to order some of these individuals that are practicing in a manner that is not lawful. Another advantage, I guess, of some of the commitments that have been made when it comes to data protection and consent, and even not necessarily focusing on, or again, I should say the provisions don't necessarily focus on women, but what they have done as a roll-on effect is ensuring that there is a reduction in discrimination and bias. And this is not only based on the provisions of, automated decision-making, which individuals now can actually ask the logic behind automated decision-making. They can also ask to appreciate, or they have to be informed of the implications of the automated decision-making, but also in terms of ensuring that again, women understand their rights. Women appreciate what is or should be done in terms of giving information and what can be withheld in that respect. One of the things, though, that is still needs to be worked on is the enforcement of regulations for I guess auditing of algorithms when it comes to, say, AI. Also when it comes to just research, basic research tools, so that we can mitigate gender biases and ensuring that digital platforms are actually fair and inclusive. This is something that is obviously ongoing, and even as emerging technologies come, it will be something that will be seen in the legal space as well as in data protection space more often. But one of the things that I think we need to we need to understand is that data protection doesn't apply in isolation. And so there are a number of instruments that are also necessary for us to have to enable, I guess, gender or women inclusion. And this not only comes in terms of policy, but also enforcement of some of the issues like we've mentioned on online harassment, which data protection laws might not necessarily counter. So in the case of the digital divide, there has been initiatives in EAC. I'll speak about the ones in Kenya, which are not necessarily, when we look at it, it's not necessarily a legal conversation, but to ensure that there is awareness. This is part of the mandate of the data protection, the Office of the Data Protection Commissioner, but also it cuts across with the Ministry of ICT in Kenya, the Communications Authority, to ensure that there is basic understanding of, I guess, digital skills, whether it's at a basic level or to an advanced level, to appreciate how to actually use digital platforms in a safe and secure manner, which then tags along or really just coupled with data protection really does come together. One of the other aspects as well is understanding of what their rights are under the Cybercrimes or Computer Misuse and Cybercrimes Act, so that if there is an instance of cyber harassment or cyberbullying, there is avenues in which individuals can actually seek redress. And so this also is a way of empowering and including women so that we're not afraid of using online platforms simply because there is a risk that we might either be exposed or be to gender-based violence or to cyber harassment or the like. Now, one of the biggest issues when it comes to women inclusion is not even on a legal sphere. It's actually aspects of advocacy as well as policy influence. And this is where organizations such as the EALS, and other members of the society can actually come in to play a very significant role in ensuring that there is a crucial focus on women inclusion when it comes to not just legislative drafting, but also regulatory enforcement. As it is, obviously, organizations such as the ODPC have a mandate to look at issues on a whole. Whilst we do look at women inclusion issues, sometimes it is very difficult for us to focus on women only. So we take things in bite size, and so there's a need for, so for example, at the moment we're looking at children's issues being a priority, but the conversation around women's inclusion when it comes to data privacy, as well as the implications of leaving or not necessarily taking particular focus on women in the digital space does need to come across, and organizations such as EALS are crucial. But also in terms of education and training for professionals when it comes to data protection and the specific vulnerabilities of women, to ensure that the legal fraternity is able to advise their clients with respect to women's rights is very, very crucial, but also enables them to support victims of either it's gender-based violence or just people who wish to appreciate or understand what their rights are in the digital space and wish to be more proactive when it comes to things like this. So these are some of the things that we need to do. Again, there is a call to action for the people that are here to push on the terms of policy and regulatory development issues, to push on aspects of women inclusion, not just in the general space of trade, but also specifically when it comes to data protection, specifically when it comes to regulatory enforcements when it comes to implementation of regulations to have a very specific I guess focus in terms of similar to what we're doing with children, a very specific focus for regulators to look at women inclusion when it comes to data protection issues, and not just have a blanket consideration for vulnerable groups without necessarily considering that women are in most cases or form in most cases majority of these vulnerable groups that we speak of very broadly in legislation. And so it's important for us to actually push that agenda as a society as well. So with that, I will stop there and pass it on back to the chair. Thank you, Angela.
Thank you very much, Ms. Mosero. I'm quite sure many of us have resonated with that. There has been a call to action, especially with advocacy and policy issues, because women are amongst the vulnerable population. Now, let us move on to our final speaker of the day, Ms. Edith Mtweve, who will discuss about privacy and gender and the various ways in which the privacy of women may be at risk. Ms. Mtweve is an advocate practicing in Tanzania, where she works as a licensed legal consultant. She predominantly works with Victory Attorneys and Consultants. That is a firm that is based in Dar es Salaam, Tanzania. However, for over 4 years, she has worked with 3 mobile network operators with their fintech and e-money subsidiaries, and a leading multinational global provider of ICT infrastructure and smart devices on data protection, privacy, arbitration compliances, and transaction. Edith has rendered privacy gap analysis and data protection policy, privacy notes, and web cookie analysis, as well as preparation of risk and control matrices and data protection and privacy compliance matrices for some of the significant mobile network operators. She was also part of the team that was tasked with drafting the model bill for data protection and privacy. She has extensively written on data protection and privacy, and also co-authored and presented a paper on the role of data in AI innovation and research that was presented at Strathmore University here in Nairobi, Kenya, during the Conference on State of Artificial Intelligence in Africa. She holds a Bachelor of Laws degrees and a Master of Laws in Oil and Gas from the University of Dar es Salaam. She also holds various arbitration and mediation trainings from the Chartered Institute of Arbitrators in Tanzania and the Tanzania National Arbitration Center. Currently, she serves as a member of the Tanzania Institute of Arbitrators Young Members Club, and she serves as the director of the Moot Court Committee, and she also organizes with the Victoria Attorneys National Moot Competition in Tanzania, and she's also a co-founder of the DAR Digital Hackers. Ms. Mtweve, over to you. Let us know how women may be at risk with regards to data protection. Thank you.
All right, thank you very much, Ms. Angela. So my presentation, first of all, started with the intersection between technology, privacy, and gender. And I believe Mr. Cephas has done a great job in elaborating how the intersection comes about when it comes to technology, privacy, and gender altogether. But I will just finally, in very simple terms, just explain how I understand the intersection, because naturally the intersection comes in a way when we use technology, let's say the use of apps, websites, or pages requires us to put our personal data. So when we put in our personal data in a bid to receive such services from these apps or websites, that data is being processed. And when that data is being processed, there could be a certain level of privacy exposure. For example, in an app, we would write our names, our email addresses, our ages, and sometimes even data that can identify us, our uniqueness. We call this biometric data or sensitive personal data. For example, your ethnic background, your eye color, and all sorts of data. So with the import of this data in these technologies, such as websites or apps, there is a level of privacy exposure. Now, this level of privacy exposure is considerably greater or higher in women than in men. The International Telecommunication Union, ITU, which is a specialized agency for information and technology, has stated that the power and transformational potential of internet access and use is not equally distributed. Of the estimated 2.6 billion people currently unconnected, the majority are women and children. This is something I like to call the paradox. It's some sort of a paradox because it does not make sense. If women and girls are the least connected to internet, are the least connected to these technologies, how are they now the most affected when it comes to their privacy exposure when it comes to the use of such technology? It's some sort of a paradox because you would assume that if men are the majority of users when it comes to these technologies, they should be the one who are highly exposed to privacy concerns. But it's actually the opposite. And that's why it's some sort of a paradox when it comes to this kind of stuff. And that's what makes it interesting for us to be be more keen to understand how does this happen. So the International Telecommunication Union, ITU, again goes on saying that the digital gender gap continues expanding in many developing countries, creating a specific need to support digital gender equality. Globally in 2022, 62 of the men were statistically reported to be using the internet as compared to 57 of the women. So you can see there is a global gap when it comes to digital gender, internet use. Men are using it more, as I previously elaborated. Another gender divide when it comes to technology is in the form of, other than the access and use of internet, gap in digital skills and use of digital tools. So men are more tech savvy than women. Also, there is a gap in participation in science and technology fields, a gap in technology entrepreneurship. So generally, this just gives you an overview that men are way ahead when it comes to the use and comprehension of technology. And just, their digital comprehension is much more than women altogether globally. And it's even larger and concerning in developing countries. But then again, comes in the question of the paradox that even though men are more, connected, women are more affected. So what is the cause factor? Today, I'm here to highlight what could be the cause factors that can bring the privacy exposures, more to women than to men who have more access to the internet and technology. So I have placed my explanation on the cause factors of this particular exposure in twofold. A simplistic approach, which is a day-to-day analysis that I will just explain in simple terms why women are more exposed to privacy concerns than men. And then there is the tech side. I will also explain a little bit, because I'm not a tech person, in terms of what my comprehension is with regards to the technological exposures, which expose the women more to privacy issues. So on a simple day-to-day analysis, women are prone to be users of technologies, or again, in simple terms, apps and websites which require, their personal, especially sensitive personal data input than men. So I would take an example, for example, when it comes to applications such as women's health, reproductive apps which require input of very sensitive personal data from women. This particular data could be, the age of the women, their menstruation, ovulation dates, their diets, their sexual preferences, their sexual state of mind and activities in a day, their moods, their mood changes, their exercise routines, and other issues, even health-related issues such as headaches, backaches, you name it. So you can understand the list is very comprehensive. It's a lot of input of very personal, sensitive data into such applications and websites. And again, these apps or these technologies, other than just receiving the input of the data, they also output the data, some data. They give you suggestions, they give you recommendations, and so forth and so forth. So you can see women are more prone to, could be more prone to targeted advertisements and targeted commercialization of their data and tracking, because they're providing a lot of this very personal, very sensitive data to these applications, which is different from men. So you can see there, even though men are more connected, but women give more information, give more of their personal data. So this makes them more prone to privacy concerns. For example, some of these apps that I've just mentioned, the women health tracking apps, have chatbot features which assist women with various concerns that they may have. Again, in these chatbot features, women put in a lot of their personal data, and then the chatbot can give them predictions and suggestions and customize responses according to the data that has been input by the women users. So that again gives them a level of exposure than men. Other than that, in some of these apps, there could be chat platforms, just like we have like a chat platform here in the Zoom call feature. So we could, in these apps, there could be also, there are some apps which have this feature where women will just, give their data in terms of what they're feeling, in terms of their, very private, intimate information about their their personal issues, sex-related topics, contraceptive related topics, which are there in the chats. So all these features and user identifying data could be anonymized from one user to another, but the app could still track the user and commercialize their data across. So these women could be more prone, for example, to receive adverts from, hospitals, clinics, IVF clinics, due to the use of their personal data. Another simplistic explanation when it comes to this paradox, which I like to call the digital gender privacy paradox, is the large use of apps for domestic activities for women than men. Women like to do a lot of bookings for their own personal domestic, stuff, for example, shopping and all that kind of stuff, than men. So they're more prone to, providing their personal information, such as their mobile number, their height, their body size, their personal addresses, their bank details, their bank debiting addresses, and the likes, than men, because women are more users than men when it comes to these kind of aspects. I mean, men use these apps as well, but it's very common for women to use them more than men. Hence, they're easily targeted, and their privacy can be jeopardized, or there could be privacy concerns when it comes to the use of such services by women than men. Another explanation or cause factor that I have is personal security concerns or online harassment, cyberbullying. Despite men being the most connected to the internet and being the most users when it comes to internet services and apps and technologies, women are often the victims when it comes to stalking and harassment than men. So, for example, through the use of social media platforms, you can see that the women are mostly being attacked more than men. And also they are more, they have more, hackers and stalkers would rather do their deeds to women than men. So it gives them a certain layer, again, of exposure, because these things are embedded in societal norms when it comes to even other than just the online platforms, even in regular life, in the physical world, women are more prone to harassment and stalking. And so this behavior is being transferred into the online platforms. And so the level of privacy concerns when it comes to women users is greater than men, who are, again, majority being the users of internet services. When it comes to now tech issues, when it comes to the technical side of things, the cost factor, which is tech in nature, some research authors such as Gebru Timnit have pointed out that recent studies have demonstrated that machine learning algorithms can discriminate based on race and gender. So the clients can be profiled on the basis of their gender. I mean, technology users, app users, website users could be targeted or profiled on the basis of their gender. And this can lead to biased conclusions when it comes to many, many aspects, such as hiring, credit scoring, and the likes. Now, when it comes to discrimination, which is in a form of profiling can lead to discrimination, in digital surveillance, as well as physical surveillance. So in terms of discrimination, when it comes to digital surveillance, when it comes to the use of technologies, the surveillance of a user's footprints in the digital world, although the justification for digital surveillance has always been for security enhancement and justified monitoring, there have been instances where gender-based discriminatory digital surveillance has been reported. So, for example, in Southeast Asia, I believe, is a great example, where it is said that digital surveillance is increasingly practiced by states on female dissidents as means to silence them. Recently, many journalists and human rights defenders in India are privy to surveillance from spyware called Pegasus. Pegasus, which was developed by Israel, an Israeli tech firm, transforms a mobile phone into a surveillance device, accessing and exporting texts, photographs, and emails without the user's knowledge. So you can see here that despite, again, men being more connected, women are more prone to, surveillance, digital surveillance. So again, a question of privacy comes into play. Their privacy is being jeopardized by the fact that they are women users. And you can see that this is actually targeted. It's a targeted privacy concern. It does not occur by default. It's being programmed to make the surveillance on the women. As well as digital attacks against women are increasingly being normalized by states that want them to be silent witnesses in their subjugation. Meanwhile, the growing sense of hypernationalism and the lack of regional cohesion in South Asia prohibits activists and journalists from neighboring countries being able to speak out collectively against such wrongdoings due to the fear that stringent actions might be taken by their respective governments against them. So you can see that women's mobile phones are being turned against them. They are being turned as spyware to do surveillance of their digital activities and to access their photos, to access their emails without their knowledge, because some governments would want to silence these women or would want to, to control these women, to monitor these women so that they will not speak out against maybe acts of the government. Some of these women are journalists or they are advocates advocating for certain rights. And so some of these governments have been targeting women specifically to silence them. So the surveillance, other than being digital surveillance, which is through the gadgets, the phones and the computers, it can also be done physically, whereby women's physical movements have been tracked, by cameras and stuff like that in the streets to just monitor women's movements in some countries. So the systems that are in place, the machine learning kind of devices that have been programmed to discriminate women and men separately, and to just focus on monitoring women's, physical movements. So this again undermines the personal autonomy and privacy of the women. This again is done by some states and sometimes even family members, such as husbands and fathers and other family members have been using technology to track the women in these different countries for different reasons. Another cause factor, which is tech-based, or another explanation rather, it is that women are more prone to privacy breaches. As I've said initially, that women, because of the societal norms and the culture of people, violating women and doing things against women in the physical world, this again transform into the online world where people still do the same. So things like doxing, which is like the publication of women's personal data without their consent, and other forms such as revenge pornography, stems from societal malpractices against women. So in this regard, you might find that most of the what can I say? How do I put this? Most of the revenge pornography, which is like, for example, a woman has a partner who's a male and they decide to record themselves. They consent to record themselves doing certain sexual acts. And when they're not in good terms anymore, the male decides to, just publish this particular video or photographs of the women. It occurs more against women than it occurs against men. And because of the societal norms that we have, women are more prone to being judged and, being more affected with these exposures than the men. And so this again is an explanation why women are more prone to these privacy breaches. It is through, because of societal norms. So an author, Divya Tiwari, explains that societal norms, gender-specific vulnerabilities, and cultural expectations spill into the digital space, and violence that is penetrated against marginalized community is in the physical world. Is replicated in the online world. Hence, why gender matters in international cybersecurity. So I have just explained here why the reasons why women are more prone to these privacy concerns. I'd just like to wrap up my presentation by elaborating the safeguards under the Personal Data Protection Act in Tanzania. What particular safeguards are available to sort of mitigate or prevent some of these exposures? So, for example, under the PDPA, the Personal Data Protection Act, the law has categorized sensitive personal data. So, as I've previously explained what sensitive personal data is, it means the law recognizes sensitive personal data. And so in recognizing sensitive personal data, the law has also kept prerequisites when it comes to processing of such data. What do you need to do? You cannot just automatically start processing sensitive personal data. There are prerequisites that have to be met in order for any data controller or data processor to be able to process such a data. Also, another aspect which has been addressed by previous speakers is the personal data impact assessment, which is under Regulation 33 of the Personal Data Protection, Data Collection and Processing Regulations, whereby data controllers and processors have to undertake personal data impact assessment when processing certain categories of data, such as sensitive personal data, as well as data protection policy approvals. The law calls for all data processors and controllers to submit their policies for approval by the Personal Data Protection Commission. So it means that the commission will have the power to see how the processing is done and how certain categories of data are, supposed to be processed by these particular data controllers and processors, as well as data security requirements, whereby the law places this particular duty on data protection officers to make sure that there exist apt security measures to protect data which is subject to processing. So my conclusive remarks is that although the law has various consideration when it comes to protection of vulnerable groups, such as conduction of personal data impact assessments and the likes, I believe there has to be certain customized measures to make sure that women who are much more vulnerable to these privacy concerns are being taken into consideration, maybe by directives or regulations or policies. However, this can be done, but it must be taken into consideration. And the considerations must aim to strike a balance between the privacy guarantees and also without affecting commerce as well. Thank you. So I'll hand over to Ms. Angela. Thank you very much.
Thank you very much, Ms. Mtweve, for your very insightful elaboration on the paradox that is there. That is that men have more coverage, but women give more. So ladies and gentlemen, remember, if you have a question, you can post it on the Q&A section or even on the chat section. I know we have had a lot of information passed on to us by our panel of experts. Now, if you remember, Mr. Cephas had just one aspect of his presentation remaining, and that is on obstacles. Mr. Cephas, you can finalize your presentation. Remember, members, you can post your observations, your reactions, or your comments on the chat section. As Mr. Cephas gets ready to finalize his presentation, Ms. Mtweve, there's a question on the Q&A section, I think, addressed to you by Mr. Aaron Kinunda on whether there has been any research, which has made a comparatively analysis leading to the conclusion that women are most affected. Is it just not a perceived issue? I think Ms. Mtweve's presentation has already answered that question, but if Ms. Mtweve, you have something to add on that, Mr. Cephas, we have your presentation, and that is on obstacles. So members, you have seen we have who does the coding and the one who advises on technical issues. We have heard from the regulator and we have heard from our practitioner. That is a well-rounded exposition on our topic. So questions are welcome. Questions, observation, even comments are welcome right after Mr. Cephas finishes his presentation on obstacles. Over to you, Mr. Cephas.
Sorry, can you hear me?
Yes, now we can hear you.
Super. Well, I was almost at the end of it, so it's going to be a brief one. I mean, within the context of the privacy and gender dimensions that have been talked about, founded by technology, built based on the technology. One of the obstacles, there are many, but one of the things I chose to highlight, because now I'm here to talk about technical, is really the capabilities and limitations that we have in our ecosystem. And we do have talent, that we must say, we do have tech talent across the various domains. But one of the things I know will be a challenge, especially for the emerging technologies, is always infrastructure. Not that I expect us to solve the infrastructure problem here, but I think it's just something we can appreciate, particularly on talking about AI related technologies. Infrastructure is quite an interesting challenge. Even expertise in some areas is an interesting challenge. But anyway, because the world is a global village, might access some of these talents offshore. Again, it's expensive. So generally, capability a challenge. Secondly, also the techniques I showed you in terms of the PTs and the privacy preserving technologies and some of the encryption methods and all that also are very like hard technical. They're hard to implement. And at the same time, I don't have the data security or data engineering capabilities as such to be able to run these systems, these computations. So generally, that's a challenge, but just for you to appreciate. Then also, the opposite of challenge is always opportunity. So straight up, what I see in terms of technology is we have the chance to build and push to market compliance enabling solutions, whether it's a simple management tool, whether it's a tool that plays at any point in the data life cycle, discovery, classification, categorization, etc. And right now, of course, the different areas of data governance are really shaping up. So whether you're in management, you're in governance, or you are in privacy, or you are whichever part of the spectrum, the opportunities to be able to build and custom local tools for whatever use case. And the beauty of that is always, again, it can be disruptive in the sense that it helps have access to some of these tools in easily and cheaper, at least cheaper than what is what we are sort of importing from the continents or developed. One of the straightforward tools that I think there's an opportunity on is compliance management for management. These are tools that that we need. Of course, we are still a very nascent market in that sense, but there is mid to long-term opportunity for digital tools to manage all this compliance work. So again, looking into the future. On a technical privacy perspective, because privacy technical is a niche area. Not that it's new, it's just niche. There's an opportunity to build practice for this. Again, our market might be a bit nascent, but with all the digital transformation initiatives and particularly businesses being product driven, there's definitely that opportunity to build a practice on the technical level. And these, of course, Ross already mentioned something to do, for example, with algorithmic reviews and audits, right? We need tools to do such stuff. That's a new area, it's a growing area. Some research is being done, but that's the frame of mind. Hey, there's a specific areas that would need specific tech solutions. Sort of build solutions. Then lastly, as well, from a professional perspective, I think there's room for privacy engineers who might be part of data engineering teams or security teams, generally data governance teams. So this basically, I think anyone could really sort of do this stuff, including guys from the legal background, with the appreciation of what data protection and privacy domain is about. It's important to just learn how to sort of translate that into technical requirements and specifications that can then be factored into design and development solution. So yes, there's room for privacy engineering. At least I see that slowly, especially with startups whose business is basically a product. At least from my quarter, I've talked to a bunch of them, and they're really curious about how to engineer privacy in their solutions. Again, this helps them to fulfill privacy by design requirement in the law. So it's a positive sum game. So that's about it for me, Angela. I think I'm always available to talk a lot about this privacy technical, privacy tech, and generally just technology and cybersecurity. So those are my contacts. Reach out if you can. Thanks.
Thank you very much, Mr. Cephas, for the insightful technical aspect of privacy. There's a question that I would like to direct to Ms. Mosero. That's on the chat section, sorry, on the Q&A section. That is by an anonymous attendee who is asking what are the elements of an offense of data breach and how do we prove the offense? I think this would be best answered from, by the regulator. So Ms. Mosero, you can answer that question and give us your closing remarks. Then we'll circle back to Ms. Ntwebe on the first question by Mr. Kinunda. Ms. Mosero, before you drop off.
Thank you. Yep. So I'll start by saying data breach is a very specific phrase or a very specific issue in the Data Protection Act. So data breach effectively is where there's an unauthorized access, or there is a loss of data, or data is disseminated without authorization, again, from the person. So it's usually, say, for example, instances of hacking, employee mistakes, someone clicking, this phishing emails and things like this. And so the responsibility in the Data Protection Act of reporting a data breach is actually on the person who's affected, which is not the individual themselves, but the entities. I'll give an example for those of us in Kenya where we had the incidents. I think this is really public information, where NIVIS had information being leaked with respect to people who'd actually signed up for its loyalty program. In that case, the office handles it in two ways. The first one usually is by looking at the sorts of safeguards that an institution has had, or has put in prior, or had put in prior to the breach occurring. And then next we'll look at the areas where they were clearly lacking in terms of compliance with the Data Protection Act. And this is looked at based on the obligations that are set out specifically in the Data Protection Act. This is privacy by default and design, instances of having a lawful basis for processing data, aspects of ensuring that they've got contractual safeguards with their data processors, the people who they engage to provide services for them. And if we find that they're failing in actually implementing some of the obligations in the Data Protection Act, what we do is we then issue an enforcement notice, which looks at or which tells the entity what they should do to then be in compliance with the Data Protection Act. And if they fail to then remedy their faults within 30 days, then we could then go and issue a fine. The fine is capped in the Data Protection Act as being not more than 5 million Kenya shillings. Again, when it comes to data breach notifications, we understand that entities find it it's not a difficult task to comply, but sometimes it's very difficult to guard yourself from the risks of, say, for example, distributed denial of services attacks, We also understand that sometimes it might be difficult to regularly audit the data protection safeguards that have been put in by data processors and things like this. So we appreciate that there are some risk factors that cannot be fully taken into account. And so in this case, we actually work with organizations to understand and appreciate what they have actually implemented, and where we find that it's lacking, then we give them time to actually remedy before we issue a fine. Now, there's another aspect when it comes to quote unquote data breaches that can be made by virtue of a complaint from an individual to the Office of the Data Protection Commissioner, where the individual claims or asserts that one of their rights has either been abused, or the processing has been done in a manner that is contrary to the provisions of the Data Protection Act, in which case then there's an investigation that will actually be conducted. Once an investigation is conducted and it needs to be done so within 90 days, then a finding of fault will usually again proceed to an enforcement notice, where the entity will be asked to take some remedial measures to counter the aspects of non-compliance with the Data Protection Act. If they fail to do so within 30 days, then a fine will be levied. There's also the aspect of compensation against an individual, in favor of an individual, where they can prove that they've suffered some sort of loss. And that's usually done on the basis of there is a regulation known as the Data Protection Complaints Handling and Enforcement Procedures Regulations that sets out how that will be looked at. And those are the two aspects of data protection. We look at mainly the obligations that an organization has. A simple example when it comes to data protection impact assessments, for example, is data protection impact assessments where there's processing relating to children or persons who are deemed to be part of a vulnerable group. So the data processing occurs. There's no data protection impact assessment that is submitted to the office for review, and someone goes off and launches a product. In this case, what we will do is we will then seek to audit their programs to ensure, firstly, that the safeguards have been put into place, but they'll also be found to have been in breach of the Data Protection Act, and then the course of ensuring that they can remedy by submitting a data protection impact assessment, halting on data processing activities as we assess the compliance of Data Protection Act and the safeguards that they've put in place. And then after that, if we find that it's substantially lacking in terms of safeguards, then we will issue an enforcement notice and a penalty notice following. Please note as well, the data protection, when it comes to the entities that are involved, is a risk-based approach. And so sometimes what applies to one entity will not be the same as what will apply to another entity, which is why a lot of the mandate or the procedural I guess elements when it comes to the regulator is actually to do audits or inspections or investigations to actually ascertain what is happening based on the nature of the organization that is involved. With that, I think I'll stop there. And with my parting remarks, I just would like to again thank EALS for the invitation to speak here. One of the things I think that is our responsibility as advocates specifically is to ensure that even as laws and regulations and policies, which usually then turn into regulations and legislative frameworks are being enacted, that we are able to utilize our powers and utilize our societies to actually push for inclusion and consideration when it comes to persons from vulnerable groups, and this includes women. Majority of the times that digital specifically legislation that touches on the digital sphere is enacted, sometimes those considerations that apply to women are actually not taken into account. And so it's a matter of us rolling back and then saying, okay, what would apply, how are women adversely affected, and what can we do? In some cases, the law does capture in a broad way, but then there is need for us to actually look into, based on our experiences, what we can actually do to inform the regulators of some of the injustices or some of the effects that may be unintentional when it comes to the enactment and the enforcement and the implementation of laws such as the Data Protection Act and its effect obviously on women. And so it is, I guess I call upon Angela as a chair of this particular committee or section that relates to women to actually engage the office, not only in Kenya, but also in other East African countries, to ensure that we have taken into consideration the effects of data privacy on women, but also are able to lobby other regulators that deal with either cyber crimes or deal with ICT and cybersecurity to ensure that we are including women, and women are able to participate in the digital space without fear of discrimination, without fear of bias, without the fear of negative application of these laws that are meant to protect them. With that, I will close, and thank you so much again, Angela, and the rest of the panelists.
Thank you very much, Ms. Mosero. Challenge accepted. Gabriel, that should be on our to-do list. We need to lobby other stakeholders and actors in the sphere, in this space, ensure that are enacted have a consideration with regard to that section. We'll go back to Ms. Tweve, whether you have anything to.
Yes, so I see the question here.
Sorry about that. I think I dropped off for like a second. Yes. Over to you. Over to you.
Yes, Mr. Aaron, concerning your question, I have mentioned a few researches that have been done when it comes to this disparity that women are more affected. But my presentation is also in form of a paper, which I will share with the ELS, which you can be able to access. But some of the papers include a paper written by Clementine Collette and Sarah Dilson, which has been published by the University of Cambridge, which is titled AI and Gender. It's very interesting. It elaborates the disparity. It elaborates the biases that are present in terms of the different AI tools that create this particular disparity, which in the end affect women the most than men. And another interesting paper that I would recommend that you read is called Gender Shades, Intersectional Accuracy Disparities in Commercial Gender Classification, which is written by Joy Bolamwini and Temet Gibru. I will also link all of these particular, there are footnotes in my presentation, which is in form of paper. So I would like to just conclude that these are the things that have been well researched, and other writers that I've quoted from Southeast Asia that have very, very directly elaborated how women are being affected when it comes to discriminative surveillance, digital surveillance, and physical surveillance. I have highlighted that as well, and it's in my paper. I have footnoted that particular source. So this is not a perceived issue. This is an actual issue which is happening. We just don't have statistics on the latter when it comes to Tanzania. I don't have statistics on the latter when it comes to East Africa even, but I just have these references from other countries that researchers have been done and publications have been made. So it is not a perceived issue. It is a real an ongoing issue, and it needs to be addressed. Hence why we have this particular webinar today. Thank you. Over to you, Ms. Angela.
Yes. For that response. response. Now, before, maybe you can talk, you can speak a bit on the quiz map for someone getting into data protection. You can speak of it, you can speak on it from the respective technical perspective.
I can see the question here. Yes. The roadmap into getting, does it mean in terms of practicing? I would just address it in terms of my profession as a lawyer. So in Tanzania, before we had the Data Protection Act, most of the clients were using the GDPR. And so how I got into data protection from my personal experience is I started advising clients when it comes to data protection then before the law came into play. And so, showcasing yourself and participating in sessions like this and also courses. I believe the university, Strathmore University, offers some very nice courses when it comes to data protection. So I think you can enroll in such courses. They're very insightful, and they will give you some sort of certification, which you can use to get into the practice, as well as writing papers. You can just write papers, articles, and on any angles, even the topic that we are having today, you can just publish it, and that's how you can get to people to be interested in whatever you are saying or doing in terms of data protection, and that's how you get into the practice. So that's from my personal perspective, but there could be other ways that people could get into the practice as well.
Miss
If I can
Tasi, first you can chime in. Yes, chime in from the technical point.
Okay, great. Wow, technical. Okay. Technical really is just about the general technology understanding. So whether you want to learn whatever technology it is, as simple as studying programming, networking, or security, or cloud, or whatever domain you choose. From a technical perspective, getting that foundation is good. I do know that even as a lawyer, particularly those who are doing privacy or tech related, at some point you want to understand technologies, right? You want to know what it is, and at least the what and the why, without having to delve so much into the how. So that appreciation with professional knowledge of any tech is important. Specifically for AI now, I know there's whole lot of excitement around AI governance, frameworks, and issues around the harms and the biases, etc. That's good, but then to make more sense, if you go and actually learn AI and foundations of what it is, how does it work at a foundational level, understand the different fashions of it, understand some applications of it, because again, if you're going to do governance, real project, you do it within an application environment, in the field. So really capturing that foundationally how tech works is important. When it comes to privacy, that technology understanding stretches, okay, because you then need now to consider, okay, fine, we're doing an assessment and we need to provide recommendations for control measures, much of which are technological based. You then need to have an appreciation of using the foundational understanding what controls actually make sense. And controls here can include simple IT things, IT actions, stretching into more security specific or security focused measures and controls. So again, understanding the technology and then considering security of that technology on top of that and the application of the same is a good way to consider the technical aspect of privacy. Another thing, because technical is not just the hard tech itself, there are also issues of governance. So if you want to explore learning governance, risks, and compliance, the GRC that Angela was talking about at the beginning, it's a great place to start, because then you will you'll be able to have the knowledge, the mindset, and learn the approaches and methodologies and the frameworks with which you can approach a risk management exercise, with which you can approach an impact assessment exercise, with which you can plan and strategize privacy program, with which you can do a lot of different things, including audit, right? Which is important to evaluate compliance status. So whatever you choose across that spectrum, it's important to also understand the governance aspects of the technology, right? And then lastly, specifically, if you want to be curious and explore more the privacy technical privacy, you then need to go further and also want to consider borrowed from traditional IT and cybersecurity, some specific issues like threats and attacks. You need to understand that, and then how you can sort of model that, so that you use that for technical privacy reviews, the same way you do a DPIA4 process. You can then, on the other side, do actual technical review, which can include scanning code, or reviewing some features and the implementations based on different factors and all that. So yeah, those are some of the specific privacy things you can consider, including exploring the privacy enhancing, privacy preserving technologies, and just understanding how they work and the context of the applications and all of that. So yeah, I hope that helps.
Okay.
Oh, maybe just one thing, Angela. Maybe just one last thing, a bit small one. So in terms of road mapping of how to get into data protection, I'll say if you're not in already, if you've just heard rumors and you know a thing or two, by the way, the best place to start is get a nice free online course and start with this. And I'm going to post like 2 links on the chat there that I would absolutely recommend. I've used it with my mentees. It has proven very, very successful. It gets you going on the lingo, on the language, of the framing and the concepts. And you can be able to survive a data privacy conversation, at that point, and then thereafter you can build on. So please start with a free course, attend some few webinars if you can, so that you join the dots. But don't jump the leap. Might need to circle back to do it. So better just start at the bottom. Thanks.
Just come again on where exactly somebody needs to start, because your audio faltered a bit.
Oh, sorry. Let me summarize.
Exactly where somebody.
Let me summarize. This is
exactly somebody needs to.
So exactly, I recommend this. 1, get a free short course. Bunch online, free short course I can share with you. I think I'm going to drop in the chat 1 or 2 nice websites I think are really straightforward. I do that course. In fact, get 3 courses, 3 very good online courses, run through them. By the time you're done with it, that should take you maybe a month or 2, if you know how fast you are. Once you do that, you'll have the lingo, you'll have the concepts, you can join the dots at the principal level. But remember, once you do that, you'll not really be able to do some of these operations practically. And that brings me to step 2. Step 2, you'd want to focus on scenario-based learning. To be honest, I haven't seen any very good scenario-based privacy resources out there, but you can reach out to me. I can share with you a few that are close related. Scenario-based learning puts you in a simulation sort of learning process. Some are gamified, some puzzle-based, so you're able to really think through. It's about building your thought process. It's about building that mindset, so that if you get an engagement or a task that needs to be done, you can clearly not figure out your first steps. that will help you then be able to be hands-on in terms of the operational privacy, because that's the one major area that you're lacking in the space. Content and knowledge and the law is one thing, but then operationally, being able to break down some of these functions and in a way that you can attack them if you get an engagement straight on and add value to an organization from day one is very, very important. So of that.
Thank you very much, Mr. Cephas. Breakdown on specifically how you can get into the technical of data protection. Ms. Whether your parting minutes.
Sorry, Ms. Angela, I couldn't get you. Ms. Angela.
Wrap up the session.
All right. So as we have seen from the presentation here, that this is a real concern when it comes to the disparity, when it comes to privacy exposure and concerns, which affect women greater than men. So it is not just a matter of gender talks or just a matter of, women this, women that, but it's an actual and evident analysis of things. And women are affected to the extent that there have been, cyberbullying, to the extent of people committing suicide and people being physically harmed. So it is high time that our laws, although we have, Tanzania has the Data Protection Act, Personal Data Protection Act of 2022. Of course, the Act has highlighted the sensitive personal data and has mentioned vulnerable groups without, explaining that women are, part of the vulnerable groups and to give them extra protection when it comes to privacy. So it is high time that, the lawmakers, the policymakers, and just all advocates when it comes to data protection take this matter into keen consideration, since now we have understood that women are more prone to face this particular privacy concerns. So to take this into consideration and to push forth, to write about, and to advocate about women when it comes to their privacy exposure and the impacts that we have seen that can affect them in the long run. So I just call upon all the people and all the lawyers and the policymakers and everybody to just take this matter into keen consideration. And thank you all for joining in. And thank you, Ms. Angela, for moderating the session. It has been lovely. Thank you very much.
Karibu sana. Mr. Cephas, your parting shot in 1 minute. Mr. Cephas, your parting shot in 1 minute.
Thank you, Angela. This has been awesome. I'm always open for everyone. I'm always open to talk about privacy and technology. Feel free to contact me if you need any help, of course, with regards to any advice around how to do privacy by design, considering privacy within your systems and solutions, all the solutions of your clients and all that. I'm always open to help. Lastly, how is that? Oh boy.
Yes, that's much better. Yes.
Okay, good. Yeah, so just saying that I'm here to help anyone who needs help around cybersecurity and technology and data protection, particularly if you want to embed privacy as part of your applications or products that you're developing, which I think is really forward-thinking idea. Then, of course, if you need to chat just generally about all of these three things, security, technology, and privacy, please reach out. And I'm also gonna, again, if you need help in terms of navigating the data privacy career, data protection space, obviously I hope to help. Thanks, Angela, and ciao, everyone.
Thank you very much to our panelists. I think we can all agree that this was a very insightful session. I know when we sent out the topic, we got some feedback that people were wondering whether it is really a live issue, but I know now we are convinced beyond all reason, beyond all doubt, that this is a very live issue, considering that we are in the information age, and it is the high time that we take some of these factors into consideration. And Mr. Cephas has given us tips as users and as consumers of these apps on what we can do to enhance the privacy and privacy enhancing technologies. For example, you look at the settings of the gadgets that you're using, you look at the default settings. If you need to go a step higher, you get some of these apps or other capabilities that will enhance your privacy. We have also had the view from the regulator, who has set out some of these risk factors, and she has thrown out a challenge to all of us that in our spheres of influence, we need to make sure that we have influenced policies so that privacy, especially through a gendered lens, can be considered, because women are part of the vulnerable groups. And then we have also had Ms. Mtwebe's very insightful presentation, whereby she has given us data and statistics on how live this issue of data protection intersects the gender issue, because the biases that women are facing in the physical world are also the same that are being translated into the digital world. So just as we are putting safeguards in this physical world, so we should also be alive, and we should also be part of the process of putting safeguards in the digital world. So with that, before you log off, we shall leave the session running for about 5 minutes, because there's a lot of information that has been put on the chat section. Mr. Cephas has put his LinkedIn profile. Ms. Mtwebe has put her email address, so that if you have any follow-up questions or if you need any assistance, they are at hand to help you. And Mr. Cephas has also put a link to one of the free courses on data protection. I think there are 2 courses there. So take your time before you drop off, just copy the links. And of course, from the Women Lawyers Committee and from the East African Law Society, it is always a pleasure to host you and to give these capacity building seminars and webinars. So with that, we have come to the end of this very insightful session. Again, feel free to contact us, East African Law Society, on X, it is Law Society. On LinkedIn, it is, and with being streamed live on YouTube. And on YouTube, our channel is East African Law Society. Please feel free to like and subscribe to the channel, because all the webinars that are given by the East African Law Society are streamed on YouTube, and you can access them there in case you would need to refresh your mind. Have a very good afternoon and a very productive evening. With that, goodbye, colleagues. And God bless you. God bless the East African Law Society, and God bless the East African community. Thank you.